Your verdict must be based solely on the evidence or lack of evidence and the law. The indictment is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of this case may be and to apply the law to those facts. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it would be helpful if you understand how a trial is conducted. At the beginning of the trial, attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final arguments. Following arguments by the attorneys, the court will instruct you on the law applicable to the case. After the instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinions on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. During the course of the trial, the court may take recesses. During these recesses, you will be permitted to go back into the jury room and take care of some things there. During these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell that individual that you're on the jury trying the case and ask that individual to stop. If he or she persists, leave that individual at once and immediately report the matter to the court deputy, who will advise me. The case must be tried by you only on the evidence presented during the trial in your presence, in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people or places described in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit any of the places mentioned in the trial or use the internet to look at maps or pictures to see any places discussed in the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communications, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet website, chat room, or blog.